first, I think we need to have a roll call, Darcy, before I go ahead and read this.
Commissioner Wilson,
Present.
Commissioner Lopes,
Here.
Commissioner Lee,
Present.
Commissioner Founds,
Here.
Commissioner Cantonwine,
Good evening, present.
Commissioner Satter,
Present.
and Commissioner Murphy.
Present.
Commissioner Peterson and Stevens are both absent tonight.
Thank you, Darcy. This meeting is now called to order of the Clackamas County Planning Commission. Is there anyone in the audience who wishes to provide public testimony on an item that is not on the agenda? If so, please indicate you wish to do so by using the raised hand button or feature on your device.
Nope, there's no one.
Thank you. The public hearing is now open for the continuation of file numbers Z0315-25-CP and Z0316-25-ZAP, an application by Michael and Mary Padden for the comprehensive plan map amendment to change the land use plan designation from the subject property from agricultural to rural, corresponding zone change from exclusive farm use to rural residential farm forest, 5 acre. Conduct of the hearing. This continued hearing will be conducted as follows. Update from the planning and zoning staff. Entry into the record of any additional correspondence received. Testimony by the applicant or representative. Maximum length 10 minutes. Testimony of anyone in the audience who wishes to speak, 3 minutes per speaker. Applicant's rebuttal, which is limited to arguments addressing evidence already in the record, maximum length 5 minutes. Closing of the public hearing, Planning Commission discussion and action. At the time, I will ask members of the Planning Commission to disclose any ex parte contacts, bias, or conflicts of interest. Please indicate the nature and extent of the ex parte contact, bias, or conflict of the interest, and indicate whether you intend to participate in or abstain from the hearing.
And to clarify, Commissioner Lee already declared last time, and there's no need to repeat that. This would just be if there's anything new.
Nothing new.
Nothing new. Okay. If anyone wishes to challenge this impartiality of any commissioner, please clearly indicate your intention to do so in any written or oral testimony you may provide. Anything? Good. Staff update. Staff will now provide an update on information related to the land use file.
Thank you. I'm going to share just a few slides. I promise I'll be quick today. Let's see. Come on. Okay. Are we seeing that in the slideshow without all the little ones on the side? Excellent. Okay, so good evening. As was noted, we are here for the continued public hearing for file number Z0315-25 and Z0316-25. This hearing was continued from January 26, 2026, earlier this year. So, and I apologize for not catching this on the script. The proposal was amended on January 26, if you recall. The proposal is for a comprehensive plan map amendment and corresponding zone change. Specifically, the proposal is to change the plan designation from agriculture to rural, and the zoning from exclusive farm use or EFU to farm forest 10 acre FF10, which is a rural zone. It's a rural residential zone. As such, this proposal does require an exception to statewide planning goal 3 agriculture. The applicant has applied for that goal exception under the irrevocably committed standard that's outlined in state law. This approval would facilitate development of 1 dwelling on the site. This is because you will also recall the site is just shy of 15 acres. It's fairly rectangular on the south side of Southeast Algier. I'm not entirely sure how to say it. The site itself is relatively flat. It is surrounded on 4 sides by other properties zoned to EFU, some of which have farm uses on them. Adjacent to the southeast corner is an existing rural residential area. It is rural exception land already and has been for some decades. So I just wanted to sort of get the lay of the land, just to refresh everyone's memory on that. And then talk a little bit about how we got here and what I'm going to talk about tonight. So as was noted, this is a continued hearing. The Planning Commission held a public hearing on January 26th. The only oral testimony received at that hearing was from the applicant. There was some discussion at that hearing with among the planning commissioners, and ultimately the Planning Commission voted to continue the hearing to today, February 23rd, and leave the record open to get some additional information. That means the record has been open. That means the record is still open and new testimony may be received today at this continued hearing. All the additional materials received between that first hearing and this hearing have been sent to the Planning Commission and posted online. That includes Exhibits 7 through 12. That includes staff additions, Exhibits 7 and 8, although 7 is just the PowerPoint from the last hearing, so I'm not going to talk about it at all. Some comments from County Council that are Exhibit 9, the applicant's additional comments in Exhibit 10, a neighbor letter that wrote, a neighbor who wrote a letter in support is Exhibit 11, and it's referenced in the applicant's materials. And then this morning, the Department of Land Conservation and Development sent a letter which was forwarded along to the Planning Commission and to the applicant as well and posted online. So that's where we are. I just wanted to run through a couple quick points that I had put in Exhibit 8 in the short memo that I sent to you. The first one is that there was some discussion at the first hearing about how would the applicant get a dwelling in the current zone, in the current EFU zone. And so there are a number of ways. I included the entirety of Section 401 from our zoning and development ordinance, which is a lot. I tried to highlight the 2 that staff felt were the most likely, given the circumstances, the size and other circumstances of this particular site. It doesn't mean those are the only ways, and it doesn't mean that there's been an assessment of if they actually do qualify. But I just wanted to give some direction on the most likely pathways for this property. And then one of them is the dwelling in conjunction with farm use. We talked a little bit about this at the first hearing. It's also known as the income test. This is the one where the property would need to be farmed. And in this case, it's considered high value farmland based on the original map soils. Under state law, it is still considered high value farmland. The property would need to generate a gross of $80,000, need to gross $80,000 annually for the previous 3 of the previous 5 years in order to potentially qualify for a dwelling. We talked a little bit about that. The other option, which we didn't really talk about, is a non-farm dwelling, because the applicant had gone through the process and gotten the soils reassessed and they've been remapped. And the soil scientist identified that a little over 50% of the soils on the property are class 4 and 6 soils. It could this property could potentially qualify for a non-farm dwelling, which does not require that you farm the dwelling. You do need to do a lot of other analysis that was highlighted in that attachment that I sent with you. So again, those are 2 that sort of jumped to the forefront of they could maybe qualify for. Also at the first hearing, the Planning Commission expressed interest in having County Council review and provide some comments. County Council did review the original application and provided a memo, which is found in Exhibit 9. I'm going to talk a little bit about that in the next couple of slides. And then finally, I just wanted to sort of ground ourselves and remind everybody that although a lot of time has been spent talking about the goal exception piece of this application, that even if the goal exception were to be approved, there are other criteria that need to be met. And specifically, the comprehensive plan policy, it talks about designating new rural exception lands, has been the subject of some discussion, and staff finds that evidence still has not been provided that these criteria are met. And in fact, in the materials that the applicant provided in Exhibit 10, unless I'm misunderstanding it, the applicant's argument essentially is that these don't have to be met. And so I don't think that that is the case. It's very clear that what they're asking for are rural lands and are rural exception lands because they're asking for a rural designation. It meets the rural lands definition that is pasted here that comes from our comprehensive plan. And they are outside of an urban growth boundary and unincorporated community. And so there doesn't seem to be any wiggle room in that policy at all. And so staff finds that they do need to meet that. So then moving on to County Council's assessment, again, that's in Exhibit 9. County Council submitted about a 2.5-3 page memo after reviewing the materials, essentially stating that they agree with staff and with Thousand Friends and DLCD, Department of Land Conservation and Development, that the proposal does not meet the standard for an irrevocably committed exception. In that letter is, I think, very clearly articulated a number of reasons that County Council finds it doesn't meet this test for irrevocably committed, including such arguments, noting such arguments as that just generally not enough evidence was provided, that the argument that the applicant appeared to be making around the proximity to an exception area, making the farm use impracticable on the subject, was based sort of on general and sort of speculative future arguments, and not actually based on existing circumstances and evidence provided showing that there is something about the adjacent properties that leads this particular property that leads to the situation where this particular property is impracticable to farm. The County Council notes that they agree with Thousand Friends that the application just simply doesn't meet the burden of proof with actual evidence to demonstrate farm use is impracticable. And also opined or noted that both LUBA and the courts have distinguished this idea of profitability from commerciality. So we talked a little bit at the last hearing about the actual definition under state law of farm use, and the definition in the statutes references using the land with an intent to make a profit. And there's been a lot of conversation about whether or not this property could be commercially farmed. But as is discussed by County Council, there is a difference between profitability and commerciality. And specifically, County Council notes that agricultural activities do not need to be commercial in scale in order to qualify as farm uses. And it's very clear that while there is not a lot of discussion about whether or not or why properties around this subject property are making a profit or are commercial farms, those are not necessarily standards in order to make the determination that there actually are farm uses. There are farm uses on adjacent properties. And those farm uses, it has not been demonstrated how those uses on adjacent properties are making it impracticable to farm this particular property. So I did forward the materials in Exhibit 10 that the applicant had sent after County Council had reviewed the original application. and he didn't have time to write another memo, but indicated to me that the additional materials do not change his conclusion. And staff agrees the materials were really focused on the suitability of the subject property for farm use, which isn't the standard. The standard of an irrevocably committed exception is really the relationship between the subject property and surrounding properties. And so both county council and staff continue to agree that this particular application has not met the standard for the irrevocably committed exception. County council went a little bit further and noted that LUBA, the Land Use Board of Appeals, has also indicated, just in case there were a situation where the Planning Commission of the board decided that this did meet the standard of of the irrevocably committed exception. In the situation where a county decides that adjoining rural development has irrevocably committed the resource land, which is largely what the arguments for the irrevocably committed exception are in the application, then we must explain how approving this exception will not present the same risk to other adjoining resource land. So in other words, if the county were to approve this exception, all of these arguments that the applicant is using for why the subject property is irrevocably committed by this neighboring exception land, that would apply to all the properties around it, who arguably then could come in and say, well, this subject property is now exception land and it's committing my property, and it creates this snowball effect. And LUBA has said that you have to demonstrate why or how this isn't going to happen, and that has not been done in this case. And he even goes farther to say as an exception cannot be approved in such circumstances when this hasn't been demonstrated. So that was a lot more words than I thought I was going to say. The short version really is that staff agrees with county council and finds that the proposal still does not meet the criteria for an irrevocably committed exception to statewide planning goal 3. It is also not consistent with all the required comprehensive plans and policies, and therefore staff still recommends denial of both of these files of the comp plan amendment and zone change in these two files. And that is it. Let's stop my sharing.
Thank you, Martha. Thank you for all that. You're extremely thorough on your work. Thank you very much for that. So next we'll be moving to the applicant's testimony. The applicant will now provide any additional information they wish the Planning Commission to consider. So who's representing the applicant? Is it Peter?
The answer is I'm here, and I'm willing. This is Pierre Finley Fry. I'm here and I'm ready to testify, but I am not making the presentation. Not exactly sure why the applicant is not available to you. I know that they're trying to get on your situation.
Commissioner Murphy, I have somebody in the audience who raised their hands. I'm not sure who it is, but if you would like, I can ask if this is the applicant's representative.
Could you please, Darcy? Thank you.
Hi there. Yeah, we are the applicants. I'm not sure why we get looped into the audience, but the Steens is the applicants. And so we have the Paynes here, and then Ty Wyman, who'll be speaking on their behalf.
Okay, thank you.
Okay, I'm going to promote you to panelist real quick.
Thank you.
Okay, Darcy? Okay, go ahead. Identify yourself, please.
Thank you very much. Ty Wyman here as attorney for the applicant. If I could get head nods from folks that you can hear me.
Yes, we can.
Thank you very much. So we submitted quite a bit of testimony by your grace, and very much appreciate you giving us a couple of weeks here to augment our prior submittal. I did try to make it very much on point, very relatively focused submittal, recognizing that the record is relatively deep. The submittal, I hope, speaks for itself. I would like to just really highlight a couple of aspects of it. We are in a decision with this many criteria and a record this long. It's very easy to let our verbiage sort of slip around a little bit. Comments have been made repeatedly that, quote, the surrounding properties are in farm use. There's no evidence of that in the record. The evidence in the record is specific and opposite to that. There may be farm activity. Farm activity is not farm use. I could be conducting farm activity in the backyard of my Portland home. That does not make us a farm use. Again, we have submitted specific information to the effect that there are not farm uses on any of the surrounding properties. Again, we've been through this before. Farm use is current employment of land for the purpose of obtaining a profit. Nobody in this neighborhood, frankly, is doing that. And now we've got specific testimony to that effect. I do at a point like this like to stress where there is agreement. I think we generally, the various commenters generally agree on the law, and the law is basically what I just said, that farm use is that current employment of land for the purpose of obtaining a profit and money, and that the standard here, the question here is whether it is practicable to put this particular property into farm use. Now, I say that I think everyone agrees on that, but then we've got to be careful, and I disagree, frankly, with how the county's lawyer, who is now advocating for the staff report, which I suppose that's fine, but that's what it is. It's an advocacy piece. Frankly, I saw this only a couple of hours ago. I wish I had been sent it contemporaneously, as we typically do. I'm going to focus on a comment at the very end of council's presentation that has been picked up by both staff as well as now DLCD has again weighed in today. And it is this, he says, were the county to approve this exception and were the subject property subsequently developed, all of the applicant's arguments for why the subject property is irrevocably committed would apply with equal force to properties adjacent to the subject property. That is absolutely untrue. And this is a quasi-judicial, and your council knows this, this is a quasi-judicial application. If the next property out wants to make its own quasi-judicial application, that application would stand or fall on its own facts. Furthermore, it makes the presumption that this property would subsequently be developed. It may, but there's no commitment to that. But this notion of a snowball effect, I can use that analogy in the same way. They're looking to preclude any extension of an exception area based on the notion that it will snowball. Whether or not the next property gets a goal exception would rest in your jurisdiction alone, because it would have to come to you, and more importantly, it would rise or fall on its own facts. And that returns me to my most basic point about this, is you've got disagreement by folks who have never been to the property. We're doing this desktop We live in this desktop remote world where we evaluate prospective farm use of properties or current farm use of properties remotely rather than listening. And I hope that in the end, this planning commission will listen to the testimony of folks, neighbors of the property, an agronomist who went on the property, as well as we have Alicia Rusher here too, one of the applicant's daughter, who surveyed the uses going on these neighboring properties. So we submitted plenty of information. We would love to hear your questions. Above all else, we want to know what you're thinking. You're getting a lot of information. Obviously, it's information, and you're hearing now very, very different perspectives. The last thing I'm going to do is Dr. Peter Finley Fry is a longtime land use planner. You heard from him last time. He submitted a memorandum a week ago on our behalf. And also I know that he has looked at, although we just got the DLCD letter a few hours ago, he has looked at that, but I would invite his comments.
So this is Peter Finley Fry. I'm the land use planner, as you know. Not only that, I also have managed now 14-acre property in an exclusive farm use zone. At the time, they allowed you to get a dwelling through a conditional use process, and that the same law applies today. From my perspective, it seems like these things shift around, and I've seen that in the testimony from the state and the county's attorney in terms of the word farm use. And Ty Wyman was very clear. This farm use has a legal definition. I'm a planner, nationally certified planner. I'm not an attorney. To me, the state definition of farm use is very black and white. It is to farm for the purpose of profit. I did see the issue of commercial. I haven't had a chance to really understand that. I assume that they're talking about somehow differentiating between profit and a commercial business. A commercial business operates for the purpose of profit. So I'm not exactly clear how the lawyers in the state have continued to essentially cut the hair in half, or cut it to try and get to what they are trying to achieve, which is unclear, except perhaps to freeze the property into a no change situation. Clearly, this property has changed in character around it from when it was first settled up and in a very large lot. And now it's a very small lot. And now there's small lots around it. Now there's a lot of dwellings around it. The situation has materially changed. That is it physically in the record. I reviewed the state's letter, and I continue to see the same confusion. I'm not sure it's intentional between farm use and farm activities inherent in their letter. I also reviewed all the applications for farm in conjunction, meeting the income test. None of those cases I really saw what I would consider a farm that is a farm under state law. They were all situations where it appeared that people were able to argue their way through the process, not necessarily meeting the purpose or intent of the law. Thank you for the opportunity to testify.
Thank you, Peter. Any now
I might ask Ms. Reinhardt, I didn't keep time on where we're at on 10 minutes.
Commissioner, would you, grant a few more minutes? You okay with that? Okay, we'll give you 3 more minutes. We haven't timed this, but I would think that we're pretty close to we're probably over 10 minutes.
Okay, no, I was just gonna, thank you very much for that. No, I was just gonna summarize. I mean, I want to stress, I respect what the staff is caught in between DLCD and landowners very much in trying to implement these basically state rules. But it's just after I'm gonna throw out there the 33 years in this business, it is just I think we've lost something when so much of the business is conducted remotely and sort of from a desktop. And that's why we really tried to present testimony that was on the site, to the effect that there may be farm activity that does not necessarily constitute farm use. And yeah, we're not. I don't. It's a false dichotomy. This dichotomy of commercial farm. I don't believe that I ever asserted here that it's got to be commercial farming. I've been pretty consistent in identifying, and I think we all have, in identifying the relevant criterion, which is, obtaining a profit from farm use of the land. So that, I think, is our 10 minutes. Again, Mr. Chair, members of the commission, very much appreciate your time. Don't envy you being put in this position, and very happy to take your questions.
Anyone from the commission have questions? Please raise your hand. I think we're okay on this end. Okay. Public testimony. Is there anyone in the audience who wishes to provide testimony? If so, please indicate by using the raised hand feature on your device. If you are on a cell phone, you will need to press *9.
I have Kelly Reed.
Go ahead. Go ahead, Darcy. Thank you. Hi, Kelly.
Hi, can you hear me?
Yes, I can.
Hi, everyone. I'm Kelly Reed. I am with the Department of Land Conservation and Development. I'm your regional representative, so I cover all of Clackamas County and Multnomah County. Thanks for having me here. I worked in the county for over 10 years. Previously worked in Oregon City. I'm familiar with the area. I wanted to be here to testify, to talk to you all, because I know I sent the letter today and you don't always get the chance to really review things in that short time period. So wanted to also attend to speak to my comments, put voice to my letter as well. So as your regional representative, I review all the plan amendments from Clackamas County that come to DLCD. Most of the time you don't hear from us, but every now and then we do have some comments to make. So we reviewed the additional materials from the applicant. We understand the applicant wants to build a home and live on the property and does not necessarily intend to farm commercially on the property. Our first letter indicated that a Goal 14 exception was required, but as the application has been amended, we agree with county staff that a Goal 14 exception is not required any longer. We encourage the applicant to pursue a farm dwelling or a non-farm dwelling if they can meet the county standards for either of those. We don't think the criteria for a exception to Goal 3 is met for irrevocably committed exception to Goal 3. The additional materials submitted by the applicant focus on the characteristics of the property itself, but do not demonstrate that the adjacent uses or development patterns have created a situation that makes the subject property impracticable for farming. We agree with county staff and county council, and we note that the farm income test, it was established over 30 years ago in the early 1990s by Land Conservation Development Commission upon direction from the state legislature. So it's been in place for over 30 years. And prior to that, the test that was in place was a farm plan, which we found that many times a promised farm plan was never implemented after a property owner got permission to build a farm dwelling. So that's kind of the background for why that farm income test was put into place. And there's some information out there about that, if you want to do more research on it. But that's all I have. And again, thank you for having us. And we agree with county staff and county council. Thank you.
Anyone from the commission have questions for Kelly? Go ahead, Michael.
Oh, thanks, Murph. Ms. Reed, I understand from what you just said that these rules and regulations were put in effect 30 years ago. Am I correct with that?
I was referring to the farm income test, the revenue that needs. I think this has been discussed at the previous meeting and this meeting. The $80,000 level on high value farmland of revenue generated in order to qualify for a farm dwelling. That's what I was referring to. Yes.
That's a long time ago. Economy has changed, and what we're living in today is not what we were living in 30 years ago. We might want to take a look at this a little bit more. I was raised on a small farm. It wasn't used for profit. It was our home, and we did farm it, but it was mostly for our own personal use. It was 100 acres, and it wasn't a commercial farm, but we raised cattle and stuff like that too. But 30 years ago seems like a long time to be looking at the way we're living today and the economy we have today, that we need to take a look at that a little bit better. Thank you.
Anyone else have questions for Kelly? Kelly, I want to thank you for your testimonies that you had mailed in. Really appreciate it. And anyone else, Darcy, that we have in the audience for testimony?
No.
Thank you. Would the applicant like to respond to Kelly's input?
Thank you for the opportunity, but no, I didn't hear anything there that really added to what was in the letter. So thank you.
Thank you very much. Thank you for all the work you did for this application. The public testimony portion of this hearing is now closed. Are there any further questions of staff from the Planning Commission? Brian, go ahead.
Yeah, a quick question. I'm still a little confused about one point. Is this particular property high value farmland or low value farmland? Where does it sit?
So it is considered, under state law, it is considered high value farmland under the criteria that are outlined in state law.
Okay. But they submitted a soils report that would indicate it might not be?
there are some land use applications that do not rely on whether or not it's considered high value or low value farmland under state law, that are truly just based on the soils. And so you have an opportunity to remap the soils. There's a process to get it approved through DLCD. And then if those remap soils show that the lot is predominantly class 4 through 8 soils, you would have the opportunity to apply for the non-farm dwelling. In addition, there would be an opportunity to apply for a zone change based on arguments that rely somewhat on the soils, but also this idea that this property was somehow either, misdesignated as agricultural land or could not be farmed. That's a different process than this exception that would be available to the applicant as well. This exception is intended, the irrevocably committed exception is really intended to demonstrate that there's something about the nature of nearby physical development that makes the resource use impracticable, as opposed to what the soils on the particular property are. Of course, you can consider that, but there is a whole separate process that doesn't require goal exception if the applicant wanted to go that route as well. Again, I am not making any judgment about whether or not it actually could meet those criteria.
We could keep it very general, just to say hypothetically, a piece of property, if it was remapped to low value farmland, would the pathway to building a home on that property be easier?
So it wouldn't be remapped to be considered low value farmland based on the criteria in state law, but the remapping would potentially allow it to get to qualify for this non-farm dwelling.
Okay.
So,
Thank you.
So Darcy, on that subject, is there a percentage point of the soil being below a certain class that makes it change this plot to a low value? Does it have, is 50% just the cutoff, so to speak?
I believe you mean Martha.
Or excuse me, yeah, Martha, I'm sorry.
For reason, Jennifer. So again, state law is very clear which mapping you have to use in order to determine whether land is high value or low value farmland. It specifically references, I don't have it in front of me, it's the soil study that was done for Clackamas County many decades ago. But state law allows for an opportunity to remap soils and apply for a very limited number of things, including this non-farm dwelling or a different type of zone change.
And I think for the non-farm dwelling, it's predominant. So it's 50% plus, whatever tiny little fraction needs to be.
With a history of this property being farmed, how does that affect this this change? If you were to do that, if you were to go to a low value, I mean, we have one of the testimonies that describe his life growing up next to it, that it had berries on it, it hayed. There was a picture sent in that it had windrows of hay. Obviously, it's been farmland, dry farmland, which, I have family that's doing that right now. And so it's not out of the question. I mean, it happens all the time.
So in section 401, 401 of our zoning and development ordinance, which I did attach, I know it's long, to Exhibit 8, it lists the specific criteria for a non-farm dwelling, and I boxed it in yellow. It starts on page 25 of that document. It does not, I'm scanning it, talk about the farming history on the property. It's based on predominantly class 4 through 8 soils. And then there's other criteria about when it was lawfully established. And then there's this analysis that has to be done with a study area that identifies, cumulative impacts, identifies what types of farming are within that study area. It's a different process. That is a very brief summary. I didn't read every single specific criteria.
Thank you. Anyone else have questions for staff? Hey, thank you, Martha. I guess it's time for us to talk about this. Anyone want to take a stab at a motion, or do you want to have a chat?
I'll
Jennifer?
call for a vote to break the ice.
Well, we need a motion first.
I think a chat would be good just because the homeowner, I want them to understand our decision. And from my perspective, I'm very sympathetic to that they bought this property and they're not allowed to do what they would like on that property. However, in the end, these laws and these zonings, in the end, are to protect farmland in the state. And this is we've already lost a lot of farmland, so we do have to be careful about what we do with the farmland we have left and protecting it from development. And they haven't met the criteria, and so that's why I personally am leaning towards denying the application as the county has, the county staff has recommended. Can't hear you, Murph.
Sorry. Out of shape. Brian, go ahead.
Thanks. My opinion is that I think we have pretty clear messaging from state level, from county council, and from staff. And therefore, I think that's where I'm leaning, even though I'm not voting. That's where I would lean. I also think that there is pretty clear pathways for the applicant to achieve what they want to achieve without the zone change. Thank you.
Louise?
Yeah, I want to kind of make a comment on a broader scale. There's lots of folks out there that shop for land that's in the natural resources zone, whether it's farm or forest. And then there's also hundreds, if not thousands, over the years who have had buyer's remorse in that they didn't really find out through due diligence what can and cannot be done with the land. They buy bare land and maybe they find out it's in a floodplain and their realtor didn't tell them. But realtors, from my experience, do not know everything about every property, all the zoning, all the rules. Some do, but not all. They buy a piece of property and find out they can't build a house on it for whatever reason. The land won't perk. That's for a septic tank. You can't get a well that actually pumps water because of the conditions of that property, and so on and so forth. So the county would be rezoning hundreds of people's property that is in a zone that, for whatever reason, restricts them from building a house on their acreage. And that's not what zoning's all about. We just can't rezone property just because a person purchased something that they can't build a house on and they can't live on. That's unfortunate, but it's buyer's remorse. And I talked in the first meeting about due diligence. With my land, I did. It took me a year to shop for it, and then another year with a team of attorneys. I hired an entire law firm to work everything out because I didn't want to commit. I don't have the funds to commit to a big purchase like that for a land that would obligate me to things I could not comply with. My property already had an old home on it, but there are rules and regulations with forest land about reforestation and how many trees and per acre, per year, et cetera, to keep in the zoning. So I went through all that. There are 14 parties at my closing. That's a lot, I was told, of people at a closing who had a financial interest in it. And I got through it. But so I didn't want to have buyer's remorse. But unfortunately, that happens. And again, it's sad, but maybe you buy a piece of land, whether it's 1 acre or 5,000 acres, and then you find out you can't live on it. And the county can't rezone those lands just so someone can build a house. So yes, and of course, I'm not going to argue with county council either. They bring up great points, and it's going to be a denial. So thank you.
Thank you, Louise. Scott, go ahead.
Thanks, Murph. Philosophically, I disagree with some of the concepts of the statewide planning goals, and I think that's a whole separate conversation. I think it kind of impedes on local control and local decision making. That said, I think Commissioner Lee made some good points about there are some pretty clear and pretty viable pathways for the applicant to achieve what they're wanting to do with this land. And so I think it would be best to direct them that way. I just wanted to go on the record with my philosophical disagreement with the statewide planning goals. Thank you for listening to my rant.
Thank you, Scott. Ryan, do you have anything? Well, of course I do. I agree with planning. I agree with Planning Council. I agree with Thousand Friends of Oregon. I agree definitely with the LCD. Scott, like you, I don't think the state planning goals are something that's just set in stone. It's a working document. It needs to be worked on. I currently am working on a rules committee with DLCD, but it's under urbanization and wetlands. Yeah, they're looking at amending Goal 5, and it's a lot of work. So I understand that state is recognizing that there needs to be change. And that's the way to do it, is to get involved and start voicing your opinion, give testimony, talk to your elected officials. This is what it's all about. We're all here for a reason. We care about what Clackamas County looks like. I very much love from field to plate. I want to protect farmland and I want to protect forest. And I think we need to really consider, where's our water going to be 50 years from now, 100 years from now? We need to really take a close look at what we're doing. And I really thank Martha for all the work you have done and all the work that the applicant's done. They said a tremendous amount of work to work on this. But the law is the law. And I kind of feel the same way as the rest of my council that we're commissioned. That the law clearly states which way we should go. So do I have a motion?
Murph, I'll make a motion to vote.
Thank you, Scott. Go ahead. Go ahead and make a motion.
So moved.
Second it.
You gotta make a motion, not
Yeah.
just say so move.
Yeah, you can't just move to vote. You have to move a specific, like,
Okay. Then somebody else can make the
whatever.
motion.
Yeah.
And I'll take notes.
The chair cannot make a motion, so someone else has to. No one's jumping to this. Like, just Okay, so what do we do here?
Commissioner Satter has her hand up, Murph.
Oh, thank you, Jennifer. Go ahead.
I will make a motion that we deny the application for the number on here. It's Z0315-25 and Z0316-25.
Do we have a second?
I'll second it.
It's been seconded by Louise. Darcy, could you please take a vote?
Commissioner Wilson,
No,
so you're voting
I'm
no
voting
against the
no,
motion.
no to deny. No to
Okay.
deny.
No to deny as in you would approve?
No, I don't approve of the motion.
Okay,
I'm
thank you.
voting no on the motion.
Thank you. Commissioner Founds,
Yes.
Commissioner Lopes,
Yes.
Commissioner Cantonwine,
Yes.
Commissioner Lee, you're abstaining.
Correct.
Okay, Commissioner Satter
Aye.
and Commissioner Murphy.
Aye. If there is no further discussion, I will call okay, we already did that. We've reached the end. This public hearing is now closed. Thank you.
So this hearing now has been, the board hearing was, I'm sorry if I missed, did we cover that, Martha? The date of the board hearing?
No.
Okay, so it's March 31st. I'm doing this off the top of my head. Tell me if I've got this wrong. Yeah, March 31st. And what's the time? I just think
I
we should
believe
be-
it's at 11. We will be sending a new notice out
Okay, perfect.
in the week.
So as I'm sure Mr. Wyman is familiar, but for the benefit of your clients, it's a de novo hearing before the Board of County Commissioners. What the Planning Commission did tonight was make a recommendation. The board will hold a new hearing, and we will be sending, we wanted to wait to make sure that we finished tonight before we sent the new public notice for the board hearing. So you certainly will be receiving that.
Thank you, Jennifer. Okay, next we're moving on to a workshop. We have a study session on ZD0393 FY 2026. Martha, are you giving that also?
Well, I need a minute or two to open up the right documents. I am giving part of the presentation. The four of us staff here in the room will be tag teaming it. But I need to sort of
So,
readjust my brain.
While you're
for-
doing that, Martha, why don't I
Right,
just say a
right.
few things and you can
Yes.
get your paperwork organized, your digital paperwork organized. So for a number of you who've been on the Planning Commission for a period of time, you'll remember that we periodically do these sets of amendments that we call the minor and time-sensitive amendments. We've had at least 3 or 4 of these packages. In a perfect world, we'd be doing one every year. The reality is it's been every 1 to 2 years, because sometimes we just haven't had the staff really to be able to do it, or we've had other code amendment packages that we had to do, like utility facilities and Lesher Farm Park, and the other things that kind of come up that sometimes have prevented us from doing the minor amendments as much as we would like. These packages are intended to be what I would call code maintenance primarily. So where we find errors, where we find places that, there's sort of confusion. Maybe we get a decision from the hearings officer that we're thinking, oh, we really never thought that worked that way. Maybe we need to take a look at that. Changes in state law where we need to comply, either typically because it's mandatory that we change something, we have to start applying it directly from state law. It's a lot easier for us if we can get it into our code. It's easier for the public. Sometimes they're optional, but amendments that we don't have to make, but that, someone has, some member of the public has requested, or some suggestion, the board has maybe asked us to pursue. But they're intended to be things that are either, as it's stated, minor or time sensitive, where we're not having to do like a whole bunch of analysis. It's not like we're going to be taking on some big thing where we've got to go out and do a ton of outreach and really kind of spend, a long period of time trying to figure out how this should work. So that's the idea. As a result, they tend to be kind of this like everything but the kitchen sink approach sometimes, where we throw a whole bunch of things in there, which tends to mean we have to talk a lot. But still the goal is that we're not making huge changes that take a lot of analysis. So we've got another one of these packages coming. And we want to talk to you about generally, just kind of to give you an overview so you know what to expect when it comes to you for public hearing. We did already talk with the Board of County Commissioners about this back in, I think it was December, if I'm remembering correctly. And so they did green light the work that we start doing this. But ultimately then there'll be a hearing before you and before the board. Your hearing we have tentatively scheduled for May 11th. So we are here tonight. We're not looking for direction, really. I mean, I think we did throw a discussion question or two in, but it's not a matter of really taking a vote. The board has already said, go ahead and let's consider these things. So we are going to be sending out public notice where it goes to CPOs, and we have to do a newspaper notice, and it goes to DLCD. It's not like individual property owner notice, but we'll do our sort of typical required notice for these type of amendments. That'll happen. Then we'll have your hearing. Then we'll have a board hearing with the goal of hopefully getting this adopted sometime before July 1st would be the goal. So that's kind of the background. The other thing I want to mention is that we have some staff here tonight that I don't believe you would have ever. Mel, have you ever been to a planning commission hearing before? I honestly can't remember.
No, I haven't. And I have to apologize. I keep getting an error message as I try to turn on my video. So this might be just my voice tonight.
There's a disembodied voice. That's okay. So a couple of staff people that you have not met before. And Nick, this is your first planning commission hearing. Is that right? Am I forgetting? I mean, tell me, I forget things.
No, that's right. This is my first time as well.
So we've got some wonderful staff people that you'll get to meet tonight for the first time. Martha is the project manager on this. So, you see Martha all the time, but we wanted to give you a little variety. So Melissa Lord, or Mel, as we call her, is a senior planner on our team. She has recently moved from reporting on the current planning side to reporting on the long range planning side. So she reports to Karen Bierig now, who you've all met. But she is still doing quite a bit of current planning, but we are getting her sort of immersed now into long range planning. So you'll be seeing more of her moving forward for code amendment type work. So she's going to give a little bit of the presentation tonight, I believe. And then Nick Hart is a planner too on our team. And he is doing mostly current planning, but we're having him dabble a little bit. He's got some great GIS skills, great code analysis skills. And so we're taking advantage of that and having him do some work, particularly on some stuff we want to do with setbacks in this package. So new faces, or at least new voices for you tonight. So that's all I have. Are you ready, Martha?
I am ready. You already were taking care of part of one of the slides, so I popped it up there.
Sorry.
I wanted to make sure that
what happens when I'm not actually I just show up and start talking and have not rehearsed at all.
No, we talked about what we were going to say. So, let me share it again. Can you see? Yes. I've also been playing around with my settings.
No, I covered that part, why we're doing this, right? But you could still summarize it because I probably missed something.
No, you didn't. Jennifer never misses anything. Yes. So we, the file number is ZDO 293, and that's the file number for the package of legislative package of code amendments that you will be seeing under the minor and time sensitive code amendments sort of heading and package. Jennifer explained, and you all probably remember what the package generally is about. Specifically, ZDO 293, this package that you will be seeing, is going to contain a lot of amendments and a lot of sections. We've sort of categorized them into 3 types. One is to implement state mandates, and I'm going to talk just a little bit about that. The other one is sort of the typical correcting errors, enhancing clarity, taking care of typos, incorrect references, and streamlining regulations and processes where it makes sense. And then we always consider requests from the public. And in this case, there is one that Mel's going to talk about. I'm going to start off and then hand it off actually to Jennifer and then Nick. So heads up, Jennifer. You'll know when we get to the slide. So if you recall, back in the fall, we had an in-person meeting with the Board of County Commissioners. And after the dinner, we had a conversation about the astounding number of state mandates that have been coming out of the legislature. And so I'm not going to go into a ton of detail about the ones that we're including in this particular package. I do want you a little bit familiar with those so you'll know what you're looking at when you see it. And so in this case, there are really sort of 6 major items, including some legislation around land divisions, this new thing called an urban housing application, a certain exemption for residential design standards that I'm not really going to talk a whole about because I don't think there's a whole lot of applicability in Clackamas County. It really has to do with certain aesthetic standards that are applied to certain types of housing. And the housing that would be subject to this, we don't really have a lot of those aesthetic criteria. And so we'll talk about that a little more probably at the hearing. I'm really going to talk about these highlighted ones here. There is an opt-in to new standards where an applicant could potentially opt into new standards that occur at a certain point in time once they have an application. Again, not going to spend a lot of time on that. There have been a number of specific use allowances that have come out of several bills that we will have to implement. And then this is going way back to something called CFEC, the Climate Friendly and Equitable Communities Rules. There are some rules around off-street parking in the urban area that we are currently implementing out of state law and we would like to put into our code for ease of administration, efficiency, and quite frankly, to create less confusion. So items number 1, 2, 5, and 6, I'm just going to touch on in a little bit more detail, and then I'm going to hand it off to the others because I'm sure you're tired of listening to me talk. So one more little step back. The items that we chose, remember there was this huge multi-page list of legislation, right? And changes that we're going to have to do. The items that we chose for this particular package are items that are either already in effect and we are just simply implementing out of state law, and it really makes more sense to update our code and implement it out of our code, or there are things that have a looming deadline, like July 1st of this year. And so we want to get ahead of some of those. And to the extent that we can implement fewer things directly out of state law, it is just really, really helpful both to staff and to our customers for understanding what has to be done. So the first big item has to do with land divisions, both middle housing land divisions and expedited land divisions. Ever since House Bill 2001 back in 2019, when we have had to allow middle housing in certain low density residential zones, there has been this thing called middle housing land divisions. There nearly every year have been changes to that. Once again, there are changes to middle housing land divisions. These are currently in effect. It changes sort of the time. They're mostly procedural. It changes the timing of when we can do a middle housing land division or when an applicant can apply. And it also allows for a concurrent review of a middle housing land division with a regular partition and subdivision. Again, this is mandatory. These are largely procedural. It does affect the way we process some of these applications, but at the end of the day, we have to do it. And the same thing with expedited land divisions. They change some of the rules. In some cases, an applicant, if there's certain circumstances and no protected overlays. An applicant can apply for their land division to be done under this expedited process. One of the big things that these changes do is it takes away the requirement for public notice. We at staff do have mixed feelings about this, but again, it's something that we have to do. It eliminates a hearing process in the case of the expedited land divisions, and it really limits who can appeal the decision. Again, these are things that we have to write into our code, and we'll navigate them as best as possible. The second one I
Martha.
wanted to talk, I'm sorry.
Martha, can I ask you a question right now?
Yeah.
Going back to that original slide you just had up there. Expedited land divisions, no public notice.
Yep.
Where's the transparency on all this?
That's a really, really good question. And I said that we have very mixed feelings about this. We as staff really do value public input. That's part of the land use process. This is something that's coming directly out of the legislation. And I think that legislators have been getting pushback that local jurisdictions are holding up processes, or NIMBYism is holding up processes, and this is one of their reactions to that.
Oh my God. Thanks.
Martha, you have much more. I see you got a couple other questions.
That's fine. I mean, I'm fine with taking questions as we go along, as long as everyone else is.
Okay, yeah, sure. Jennifer, go ahead.
I was wondering if you could send us the legislation, the number, the House bill or Senate bill or whatever it was.
Yes.
So that, I mean, for those of us that have concerns about these processes being eroded, that maybe, you know, your next door neighbor wants to put a subdivision in, or, you know, it does affect you. If you don't get to appeal it, then that's can really affect people's property that they own. So that we can see at least how our individual, we don't all probably have the same people in Salem, but we might want to contact them and keep a closer eye on what they're voting for and against.
So yes, I can. I was just looking at the attachment that I sent you, and the bill numbers are not on there. It was on the attachment way back when we originally talked about this, but I can certainly provide some updated information for you after later this week.
Thank you.
Louise?
Yeah, just I'm a little confused. Like, what constitutes an expedited land division? Who starts the process? Who gets to have one of these? Where do they come from? It sounds almost like from out of the blue. So, you know, what's this all about? You know, is it a developer who's bought a tract of land and they want to suddenly divide it real quick so they can build for middle housing? You know, a little more on that, if you could, please.
So I'll do my best, and I may need to phone a friend like Jennifer or Nick or Mel because I don't process land divisions, and expedited land divisions are not a new thing in state law. It's just that these specific provisions around an expedited land division are new. Expedited land divisions have been an option available to developers for a long time. It's something that needs to be opted into. It doesn't mean that they don't have to meet the regular standards of a land division. It just means that in a lot of cases, we need to process it a little bit faster than the standard process. And now in this case, it means that even our notification process is different. My understanding of expedited land divisions is that there are a specific set of circumstances that need to be present on the property. In other words, there can't be any protected areas like habitat areas or other Goal 5 resources or floodplain. It's for land divisions that are sort of your real straightforward. We don't see a lot of them probably in the urban area sort of just an unencumbered piece of property. I don't know if anyone else wants to jump in and unravel what mess I just made of that.
I don't think you did make a mess of it, but I bet you Nick's going to correct me with whatever I get wrong. Unless this legislation changed it, they only apply, did you say that? Only apply in urban areas. So we know.
No, I did not.
Yeah. So unless this bill changed it, they're only applicable in urban areas, and correct, they can't have any like goal 5 protected areas. But they just sort of, honestly, they just kind of keep rolling back process. It's hard. It's getting hard for me to keep track because I think at last count, we're up to something like maybe 6 different processes now with all these different permutations of how many days we have to issue a decision and who we can notify or who's allowed to appeal and where the appeal goes. And I think we're going to have to create some huge matrix. And so that's just to try to understand it all. And that's the part I think that's particularly frustrating. And yes, the bypassing of the public notice process is, definitely not ideal from the perspective of, I think, of the community.
Well, thank you, because that's a little more clear than before. I was like, what is that?
Yeah, it's supposed to be faster, although in truth, I'm not sure it's truly faster exactly, but it definitely is going to reduce appeals. So it'll be faster in that respect.
Go ahead, Martha.
Okay, I'm going to move on. An urban housing application. So this is one of these other new processes that the state has created. And although the language is not particularly clear, we have actually been discussing it internally today. The state has created a new application type called an urban housing application. It only applies in the urban area, and it seems to only apply to these specific application types. And it only applies to these specific application types if they are for residential purposes. So a zone change, just to be clear, that would be only a zone change, not a comp plan amendment zone change. There are some plan designations like the rural designation we were just talking about that has several different zones that could implement it, and you could switch between those zones without changing the comp plan designation. For planned unit developments, which are not defined in state law, although we have a very specific definition of what we think a planned unit development is in our code. It's a specific type of subdivision. And then variances. And so this new urban housing application, again, has a limited notice and comment period. It's a different timeline, like Jennifer noted. You are not allowed to have a public hearing on your initial decision. Which for a variance, we wouldn't anyway under our code, although for a zone change and for a planned unit development, we likely would, depending how big the PUD is. It is appealable. You can have a hearing upon appeal, but it's just one of these things that we need to add to our code. It's yet another way, method, and process that is intended to help move housing approvals through faster.
Martha, I ask.
Oh, dang it.
Almost got off that page. I'm timing you.
I forgot I was going to highlight these, so go ahead.
No public hearing. Is that going to lower the cost of the application? Or is that a decision by the Board of County Commissioners?
That is a good question. I guess that's a decision by the Board of County Commissioners, although there is a hearings officer fee associated with items that go to the hearing. So I guess presumably we wouldn't be able to charge that if it's not going to hearing.
Correct. Yeah, we charge extra for ones that go to hearing because we have to pay the hearings officer, so they wouldn't have to pay that hearings officer charge. But the actual application fee, that part wouldn't change unless the board changes the fee structure.
Okay, I'm done. Thank you.
Okay. This category that I call special use allowances, there are a number of these. These are not related generally. That it's coming from a number of different bills. But what seems to be happening, and we talked a little bit about this back in the fall, is that there are these specific uses identified by the legislature that a jurisdiction must allow in specific areas, certain zoned areas, areas that are owned by certain entities, in any zoning, areas that are operated by certain entities. And it's becoming very confusing. I'm trying to create a table, and I need like a 3-dimensional table because it's so confusing. So I haven't quite figured out how to do that. But in this round, the specific uses that we are going to add to our zoning code are residential treatment facilities and residential treatment homes. State law has a definition of those. Those are already allowed in some areas in our code. And so what we would be doing is making sure that everything in the state law, where it says it needs to be allowed outright without, for example, a conditional use permit, that we are allowing as a primary use. Nothing in this means that we can't apply development standards to it. So if one of these facilities needs to go through a design review and meet certain development standards, we would still be able to apply that. What this affects generally are residential zones and commercial zones and lighter industrial zones. Most of these actually do have a specific exclusion for heavy industrial zones, is what they call them. In Clackamas County, that is general industrial. Again, this is in the urban area. Same thing with mental or psychiatric hospitals and crisis stabilization centers. Those need to co-locate, but we are now required to allow those in a number of different zones as a primary use. Again, can send them through development review. Child care centers, there's been a couple of bills related to child care centers. And child care centers also have, the definition of them has greatly expanded. This one actually applies not only to the urban areas. There are some changes in the rural areas for child care centers, although those are limited really to child care centers that are co-locating with a community center that's allowed in the rural area. It's a community center or a school in the rural area. Inside the urban area, child care centers are now allowed as a primary use nearly everywhere. In residential zones, in our medium and high density residential zones, they have to be allowed as a primary use. Commercial zones, most of the industrial zones, again, not heavy industrial. Other lower density residential zones, it's allowed, but it would have to co-locate with certain specific types of institutional uses that are listed in the statute. I'm almost done, and then I'll take your question, Commissioner Wilson. Another item is emergency shelters, and we are actually currently implementing emergency shelter requirements out of state law and have approved 2 of them over the last several years. Again, this is one of those, one of the pieces of legislation that states that we have to allow emergency shelter siting in nearly every zone. This one is tied to specifically who is operating the emergency shelter. And there is a sunset. It used to be a date, but now the sunset is really only once the point in time count shows that the homeless count is below a certain percentage of the population on a statewide level. It is well above that now. I imagine this is going to be in our code for quite some time. And then there was this small little provision that requires that we allow preschools and pre-kindergartens associated with a place of worship. We had already allowed certain types of daycare facilities, but this one is specific to schools. Other schools, kindergarten, K through 12, if they want to locate with a place of worship, they potentially can, but they have to go through a conditional use process like any other school would in the particular zone if it's allowed. So, yes.
This emergency shelter siting, what kind of notice is given for that? Do you know?
I do know, and no notice is given. So the emergency, I don't know why I can't say it. The emergency shelter siting has been a requirement for a couple to 3 years. I don't know if Jennifer remembers. it's the legislation, it's now in the statute, specifically says this is not a land use decision. Notice is not required, and the county has to approve it if this certain list of criteria are met. And so back when this came about, Jennifer and a few other planning staff went and spoke with the Board of County Commissioners and presented sort of the options for how we would review this. And the board directed the planning department to create a process. There's still an application. It's not a land use decision, but we do need to review the criteria. And then because we have to approve this, if it meets a certain criteria, the board opted to not send a notice ahead of time. A notice of decision is sent to neighbors, I want to say within 300 feet. I don't know off the top of my head if it's 300 feet or 100 feet. And again, this is in the urban area.
Okay, thank you.
Martha, on emergency shelter siting, this kind of strikes a chord with me. Would this include post-transitional housing, emergency housing, in case we have a forest fire and we have 1,000 people without homes? Where do we put them? This was something I've brought to the board before, and I think it really needs to be focused. I see Lynn County just has passed something where they do have some areas that they're going to lay out as post-transitional housing, where they could take FEMA trailers if they had to in park, or people could be there for a year plus 2 while their homes are recovering.
Honestly, I would need to reread the rules. I don't think that is the intent of it, but whether or not you could use it for that, I actually would need to reread. And I know that we've had a conversation about this in the past, Jennifer. I'm not sure if you recall. It is specifically worded, for people who are homeless. I don't know that it's
Arguably.
specific to a reason for that, but I would need to reread that to know for sure.
There are also some provisions, which I am going to have to delve into. That slide will be coming up, Murph, that had to deal with after the terrible wildfires in 2020. DLCD did some rulemaking. I think there's also been, I can't remember if there's also some statutes, but anyway, they added some things for some temporary options, some of which is sort of as simple as you can live in an RV on your own property when your home burns. But there's also some other more, congregate's not the quite the right word, but the ability to have some sort of temporary housing for people who've been displaced. And I don't think it's unique to the 2020 wildfires. I think that it's more applicable than that. And actually, LCDC is going to be considering extending some of the time frames because, for instance, in Lane County, there's a lot of recovery still to happen from those fires, even though it's been, 5.5 years or whatnot. So we'll be delving into that as well because we've never put any of that in our code, even though they did, add some rules. So there may be some other things, but I can't give you all the details off the top of my head.
Well, if I could emphasize that, I had a conversation with the mayor of Talent, and she said this was one of the biggest heartaches that they had. They lost 1,600 homes at once, and they had FEMA trailers available. But they had no place to put them because of zoning. Zoning did not allow them to put them in a certain area. There was no infrastructure planned either. And she said, so instead of being able to house these people, they lived on cots for months and months while this process went through.
Mm-hmm.
Get it done now because it's come. If you live in a wildfire neighborhood, which I do, it's going to happen. And so I'm going to you're going to hear me squeak. Thank you.
Okay, I'm going to move on. I have one more slide. I think. Maybe. Excellent. Oh, everyone's favorite topic, off-street parking. So, several years ago, there were, this actually was rulemaking that created these rules. This wasn't specific legislation. It was at direction of the governor that created some rules for what is called the climate-friendly and equitable communities rules, part of which related to parking. There are a number of CFEC rules. Karen Burig, I think you're aware, is currently in the process of working with transportation planning staff and updating the transportation system plan. A lot of these CFEC rules relate to that process, so you are going to be hearing about this again. But what really directly affects our zoning and development ordinance are off-street parking requirements in the urban area. And so we did have some conversations about this a couple of years ago. The important things to keep in mind with this particular conversation is that CFEC required the county to do something in its urban area. Because the county has not yet done anything, as of July 1st, 2024, we are not allowed to enforce any minimum off-street parking requirements for development in the urban area, in the urban unincorporated area. We are currently implementing this directly out of state law. Again, it is confusing because the parking section of our zoning code says there are parking requirements, but there are not. And so we are proposing simply to codify that into our ZDO. There are also some maximum off-street parking requirements in certain areas. We do have maximums in our code. They don't exactly line up. They're pretty close. And then part of this is if a requirement, there are some tree canopy and other design standards for the development of a parking lot. If somebody were to provide a parking lot over half an acre with their development, there are certain development standards that have to be met. The important thing also to keep in mind is just because we cannot require off-street parking, we can allow it. And I actually sent out an email to all the planners, the current planners today, and asked if anyone had approved in the last nearly 2 years any urban developments with no parking. And I got crickets, although Mel did respond to me and say no. I mostly got crickets, which I knew was going to be the answer. The developments that are happening in the urban area, the developers are still providing parking. Now, is it the amount of parking that would have been required under our code? In some cases, probably not. But development in the urban area is still providing parking. I know that there was a proposal for one development that I'm aware of with no parking, but it was in the pre-application stage, and I don't know if it's really going to move forward. I think there is an understanding among developers that Clackamas County is still very much a suburban community and people drive. And quite frankly, a lot of our roads do not have good on-street parking. So that is sort of my long drawn out way of saying this sounds really scary. And it sounded scary at the time, but for nearly 2 years, we have actually been implementing no requirement for off-street parking. And I can tell you that development is still providing parking. So, yes, Commissioner Murphy.
Yes, thank you. Well, Darcy, I remember back during the middle housing talk, we were talking about not requiring parking if it was within a quarter mile of mass transit. Is that correct? Something like that? And if it was outside that range, then you would require 1.5 parking spaces per 3-bedroom or something of that nature. I remember there was a formula for it.
Yes, you remember correctly. CFEC, there were sort of 2 phases. The first phase was this elimination of off-street parking requirements within a certain distance of transit, which is what you're remembering. And outside of that, we could still require off-street parking. That was the first phase that, well, I guess for us, that transitioned into the second phase on July 1st, 2024, in which we could not require off-street parking anywhere in the urban area. Is the simple version of it, Murph.
Thank you.
Okay. All right. So this is where I start to hand things off. That's all I really wanted to touch on with the state mandates and legislation. The sort of second bucket of code amendments falls under this idea of correcting errors, enhancing clarity, streamlining our code in areas that we think it needs to be streamlined, in some cases specifically to reduce development barriers. There's sort of 4 items under here. We're going to really touch on 3 of these items. Clarifications and housekeeping is fairly self-explanatory. You'll see those edits in the package that you get in a month or so. And so the first one is amendments to farm and forest lands. I'm going to have Jennifer talk a little bit about that. There's a slide, Jennifer. And then reducing development barriers. There's a number of items that might be included under there. What Nick is going to talk about today specifically is setbacks. And then Mel's going to talk about some potential changes that we might make to how we regulate docks on the Willamette River. So take it away, Jennifer.
Thank you, Martha.
She's got to read the slide first. I don't know if she's seen it.
Yeah, I haven't, but that's okay. I'll just wing it like I always do. This is pretty good though, because I made notes and I'm thinking, what was all that rulemaking? And my notes match what you put on the slide. So apparently I'm doing okay. For some of you old timers on the Planning Commission, of which we have at least a couple, although Tom and Tammy are not here tonight, but there's still maybe a couple of you that remember. We began, gosh, at this point, it's been like 12 or 13 years ago, we started doing an audit of our zoning and development ordinance. And we stole that term from some other jurisdiction because I thought it described it pretty well. And it was like, we're going to go through the code from beginning to end and just sort of like do this massive cleanup. And we created a work program and divided it up into like 5 years, and then promptly spent 5 years getting through like 3 phases of it, you know, the typical thing. And it ultimately got put on hold for a variety of reasons. And we never, there's still parts of the code that have not been, quote, audited, although I think we're going to start getting to more and more of that work through the ZDO diagnostic report that you've heard about. But what we also didn't do was audit our exclusive farm use, timber, and ag forest zones. Those are the ones that, as most of you know, are heavily dictated by state law. The county has not a lot of flexibility. We do have some ability to define terms sometimes in those zones. Like if the state hasn't defined something that's vague, we're allowed to adopt our own definition. And we're allowed to be more restrictive than state law sometimes. Sometimes we can't do that, but sometimes we can. So we're pretty limited, but what happens is the state changes the rules all the time. I mean, nearly every time, probably every time the legislature meets, something comes out that changes something in one of these zones. And then DLCD will often have to do rulemaking and then, you know, et cetera, et cetera. So it's sort of this constant cycle of updates. And it's very easy to get disconnected from state law because it's changing so much. And so the idea here is to actually like look at pretty much every word, like to look at these 3 sections of the code that regulate these 3 zones. Look at state laws, both the statute and the administrative rules, and figure out what might, because I can tell you, I already know we have errors, but we probably have errors I don't know about. And so it's to comb through and figure out what are we missing, and to get it completely consistent with state law updated. So that's one aspect of this project. Commissioner Wilson, did you have a question?
Jennifer, I'd like to know what percentage of Clackamas County falls under these farm and forest areas?
That's a great question. I don't know, like half. I mean, I don't know, a lot. I mean, if you exclude so the National Forest is all technically zone timber. The reality though is because it's federal land, we have limited ability to regulate it. There are some circumstances where we can, but technically it's all zone timber. But even excluding that, I wouldn't be surprised if it was half. Does anybody else on my team want to guess? Because I mean, I could eyeball a map, but Nick could run us some GIS stats and just get you an answer, I bet, because it is sort of interesting. But just
and
I just don't know.
That would be the percentage of the area, the acreage or whatever.
Right.
But what about population?
Oh, not a lot of the population. That would be far less than that, but I don't know exactly. We're split roughly equal urban and rural, I believe, in the county. So the county population is just over 400,000. That's what I've been told. Martha's looking skeptical, but I know at one point, if you take into account cities and urban unincorporated, I thought it was about 50-50 at one point.
Just trying to understand how many people are going to be affected by this. The area is important, but also more important is what the population that's going to be affected by these amendments.
Right. And maybe it's more like 50% of the unincorporated population is rural. Does that sound better, Martha? Because what the stats I just pulled, we had about 186,000 people roughly in unincorporated Clackamas County.
Okay.
So that would be more like probably about a 50-50 split. Yeah.
Yeah.
Just trying to get some feel for what we're going to be affecting here.
Yeah. But even the 50, even if we had, let's say, 100,000 people living in the rural area, a lot of those are on rural residential land, Commissioner Wilson. So they're not TBR, Ag Forest, and EFU. Because these three zones, of course, have much larger lot sizes. A lot of them, as we learned from our earlier item tonight, aren't even allowed to have a house. So population-wise, it's going to be relatively small, but obviously relatively large in terms of acreage. So it's a lot of people we're affecting, but we're not actually changing the rules. I mean, the rules have already changed. The state law is what the state law is, and we're required to implement it. So although we're changing our code, it's really more about getting ourselves in sync with state law, some of which we're trying to apply directly now anyway. And it just becomes really difficult because it's sort of what we explained earlier. Having to look both places is difficult for the public and difficult for staff. So the idea is to just get our code current with what we're supposed to be doing anyway.
Okay.
We're going to remove references to the state wildfire map. So as some of you may recall, the state went through this exercise of adopting a wildfire hazard map over a period of years. It was extremely controversial, and the legislature last session then repealed the wildfire map. So no longer exists. And so we've got some outdated references that we need to just pull out of our code because there is no map anymore. And in addition, DLCD went through some rulemaking. These rules took effect a year ago, January, not just last month, but a year ago. And they were essentially trying to do, I guess I'll call it a cleanup of some things primarily related to the exclusive farm use zone, based in large part on case law. Because these things, as we know, lead to, people file for a land use application, somebody appeals it, or it gets denied and somebody appeals it. And then the courts start defining sort of, well, what do these vague words in state law mean? And so the idea was to actually specifically add into the rules some of these things the courts had already determined so that it's easier for staff around the state to find out, to find these things, to know, oh, we're supposed to be applying these things that the court told us to apply. So that's the case with some of these rules. And then in a couple cases, they were addressing like definitions that there was no clear definition. And so they adopted a definition, for instance, of private park that they didn't have before, because private parks are allowed in EFU, but there was no definition for what that was. There's something called the Farm and Forest Impacts Test that applies to a whole bunch of uses in these resource zones. And it was like, well, what does that actually mean? The courts have fleshed that out somewhat. So now we have to codify that. What does it mean when you need to go through one of these Farm and Forest Impacts Tests? Agritourism, which has been an allowed use for a number of years, but there's some specific standards that weren't necessarily very clear. The courts have fleshed those out a bit. And so now that clarification has been added to the rules, and we need to add it to our code. They adopted something specific. So for those farm income dwellings that we were talking about earlier tonight with the $80,000 standard, there's been a question about, well, how does an applicant demonstrate that they actually made enough money to qualify? And so DLCD adopted a rule that said at a minimum, they have to provide an IRS tax transcript, which apparently is relatively easy to obtain. And so that's the minimum standard now. We can require more, but they at least have to provide that. So we need to add that to our code. Home occupations, they adopted some new standards that regulate certain types of home occupations where people were sort of using a home occupation to try to maybe bypass some of the standards that would normally apply to that use that was allowed like as not a home occupation. So the rules were intended to say, well, if you're going to try to do this as a home occupation, you still have to meet the same standards that would apply it to somebody who wasn't doing it as a home occupation. So kind of technical, and I'm not sure they actually succeeded, frankly, in their efforts for that particular change. They did some housekeeping related to preparation of farm products. They had sort of this circular reference in the rules that, so they cleared that up. And Martha's got it noted here, transportation facilities. They clarified that certain transportation facilities in the EFU zone are subject to this farm impacts test. So it's a lot of pretty technical stuff, but it is the law now. So we're having to apply these things directly out of state law. But it definitely does impose some requirements on property owners that in some cases they did not previously have. It's just not within our control to decide not to apply these things. So I'm happy to take other questions, or we can move along. Okay, seeing none.
So we are going to hand it off to Nick, who has been doing a lot of work with our setbacks.
Thanks, Martha. My name's Nick. I think you all know me now because Jennifer introduced me at the start, but I've been working on this project with relations to some of our setback standards. So the way that setbacks are measured in the ZDO, Martha's provided the definition here. A setback is the shortest horizontal distance between a structure and the lot line. And so what we're looking at with this code amendments package is not actually changing the number that's assigned to that horizontal distance. If a setback is 5 feet from a lot line today, it will be 5 feet from a lot line. When we're done with this process, really what we're looking at is where are the lot lines on these lots as people are dividing land and developing. The reason this is necessary is that when the ZDO was adopted and even the zoning ordinance before that, there were a lot of standards that controlled the shapes of lots that people could make that required them to consolidate lots that didn't conform to those requirements. And so it was a relatively controlled environment where most people were producing square lots on which they put square houses. It made measuring things really easy, and the zoning code standards were also quite easy to write. Over time, a lot of those controls on lot shapes and lot sizes have gone away, and as a result, this like relatively simple structure for measuring and assigning lot lines has started to fall down a little bit. And so our hope with this package is just to clear up some places where we as staff have identified in the course of reviewing building permits and land divisions where our current setback standards make things not super clear for applicants, not super clear for staff, and just try and make it so that when everyone looks at a lot, they see things the same way. And it's a way that's consistent with what we've sort of always done. We're not trying to increase or decrease how much setback or where setbacks are on properties with this. We're just trying to make it consistent. And so there's a number of slides that I'll follow here that just sort of give examples of some of the things we're trying to address, and I can talk through them really quickly because sometimes pictures are a little bit easier than words. So Martha, if you want to click on to the next slide.
There you go.
Thank you. This first one's a great example of two lots that kind of look like regular old flag lots, except they provided in the yellow shade there an access easement that pokes into the lots. Because of the way that our zoning code relates to access easements, it says they're functionally roads. And so you have to measure your setback from the road, which in this case sticks way further into the lot than the developer thought it would. And it created kind of a problem for them because on the backside of these particular lots, there's some quite steep slopes that they were hoping to avoid. And so trying to make situations like this one where a setback takes away a lot more of the lot than the developer thought, because what they thought was a simple access easement actually ended up being a road. Wasn't very clear to them or clear to staff as they were helping the applicant through their application. Example 2 is an example of a flag lot that this one has 7 sides. Flag lots were not a thing when the zoning and development ordinance was adopted, and the picture that eventually got added to the zoning and development ordinance contemplates a flag lot that looks like a flag. A pole goes up one side and a rectangle sticks off of it. And the language for those flag lots just doesn't work when a flag lot is shaped like a lollipop or has 7 sides. And so we're trying to make the way that our flag lots setbacks work a little bit more robust and a little bit more able to handle some of the more interesting lot shapes that we're seeing throughout the county. Another somewhat recent development, particularly in sort of infill situations where people are doing planned unit developments or smaller lot subdivisions, are the fact that fire truck turnarounds are actually quite large dimensionally. And they, at one point, almost certainly weren't required back in the 70s and 80s. And now they are. And so we're getting interesting geometries. You can see on each of these, there's kind of a road that doesn't make a lot of sense, and that's to accommodate the fire truck and emergency vehicle turnarounds. But it also produces setbacks that in some cases reach nearly to the back of lots, which has not really ever been the intention. And so trying to come up with a way that we can recognize the importance of having a fire truck turnaround in space for emergency vehicles while also making sure that we're not accidentally putting people into a corner where their lot is half the size they thought it was. Curved roads is another one. I'm not sure that curved roads are a new invention, but it's something that we've seen a lot more of. Both of these are examples from a new subdivision that I think was in 2023. And so where our zoning code looks at a lot that isn't a perfectly square corner lot and isn't a perfect geometric triangle, it doesn't really have a great answer for where your front and rear lot lines are. And so just trying to make some small language changes in order to allow these lots to develop the same as if they were either a squared off corner lot or a triangle lot, under the existing allowances, just being a little bit more flexible when the road is curved. And example 7, this is a good one for back in the day, in the 70s particularly. There were lot frontage standards. So if you wanted to create a new lot, you needed to have, say, 50 feet of frontage on a public road. That standard's been gone for quite a long time. And so now here are 2 examples of lots that do not have 50 feet of frontage, but the way that a front lot line and a rear lot line are assigned in the code has not changed to reflect that. And so you get these kind of partial front setbacks and partial rear setbacks that are not super desirable outcomes and are quite confusing for both staff and applicants. So this is just another example of where, with some relatively minor language changes, we're able to make things work as intended and make things a little bit more clear for applicants. And I think that's my last example. The very last one is just a situation that we see coming up, not a ton, but sometimes, where someone has an access easement that runs all the way across their lot. And much like the very first example, actually, these access easements that cross lots create setbacks in places that people don't expect them. And so everything located sort of to the left of the blue shaded private access easement on this slide is effectively unbuildable because there's a 20-foot front setback protruding off of that access easement that almost certainly wasn't contemplated when they were putting the subdivision together, but nonetheless, that's what the code has said since the 80s. And so just trying to make sure that when we're looking at these standards, they're actually accomplishing what we want them to accomplish, and not just the function of the text that has maybe stayed a little longer than it ought to have. And so I think 8 was my last example, but Commissioner Wilson?
Yeah. Mr. Hart, thanks for your input here. Enjoy meeting you and hearing your comment. I think I know why, but I want to know why, from your perspective, why do we have setbacks?
Sure. I'll speak to it a little bit. Maybe Jennifer will chime in if I miss something. But setbacks generally provide for a number of things. There's potentially aesthetic considerations about having development be orderly in a certain way, front yards, backyards, side yards. Actually, in the very first versions of the zoning code, they weren't called setbacks. They were called front yard depths and rear yard depths. There's separations from buildings, from your neighbor's buildings, and things like that. But these sort of depths and sizes of setbacks is not really what we're hoping to get at with this package. We're really trying to focus on where the lot lines are assigned by the zoning code, which then enables us to apply these setbacks in a consistent way, and potentially sets us up well to have the policy discussion of, well, how far should this setback be? But generally speaking, setbacks serve a number of functions. It's not really within the scope of what we're looking at here to change the distances, but we're just trying to make sure that we're applying the ones we have currently consistently.
Thank you very much.
Commissioner Murphy?
Thank you, Nick. Yeah, and some of that setback has something to do with wildfire. In my neighborhood, I have to move a woodshed because it's too close to my home. Or I can't be so close to my neighbor's home because now we don't have the clearance, and our insurance can be dropped or something of that nature. So we're going through where insurance companies are starting to dictate what setbacks should be. And it would sure be great if they could review some of these plans so we could, get all on the same table. So you don't buy a house and find out that, oh, this doesn't meet the setbacks of insurance, what the underwriters are requiring. So now we have to jump through hoops to make certain changes. And sometimes it's kind of scary when this happens. I feel for you because, you'll be seeing different dimensions that you probably don't expect.
Certainly. And I think that's another great example of how the different distances that could be applied in a setback have different purposes. Hopefully what we're doing with this package is enabling us to have a strong foundation to have those later discussions about what appropriate distances look like in different contexts.
Thank you.
Right. Any other questions about setbacks? There'll be more specific language and stuff coming in your next packet, but this is just a primer to understand what we're looking at here.
Okay, I think we're going to move on then. We are going to talk about docks on the Willamette River. And, well,
yeah, thank you, Martha. And good evening, folks. Again, I apologize for not having my camera functioning tonight, but as Jennifer mentioned, I've been with the county for 5 years, but recently transitioned onto the long-range planning team. So hopefully you'll be seeing more of me in the in the future with our projects that we're working on. But tonight I've got a couple slides here to talk to you about docks on the Willamette River. Just for some context, the Willamette River Greenway is established through the statewide planning goal 15. It's the corridor of water and the surrounding land, which development is planned and built specifically with recognition to, the uniqueness or qualities of the Willamette River. To implement Goal 15, cities and counties, including ours, we're required to adopt a Willamette River Greenway boundary and to establish policies and standards for new development, new uses, intensification of uses within that boundary area. Now, the packet you received, there was a map that showed the extent of the Willamette River Greenway boundary within the county. The standards were intended to maintain physical and visual access to the river, preserve habitat or vegetation near the river, and generally to direct development away from the river. But directing development away from the river does not necessarily mean development was prohibited. Section 705 of the county's zoning and development ordinance regulates private non-commercial docks. We regulate size of docks, boathouses, the color and material of docks, wanting things like wood materials and earth tone colors. And the state also permits and regulates aspects of docks, but doesn't specifically limit the square footage of docks like the county does. We'll be looking a little bit more into that dock size and regulations of docks in the future, but for right now, I do want to talk more so about the limited use area of the Willamette River Greenway. We have two classifications of water uses and the Willamette River Greenway design plan. It's a mouthful. Limited use and multiple use. The uses identified for the limited use designation are generally described as uses compatible with limited use recreation. Other uses are existing residential, commercial, industrial, water-dependent uses. In the multiple use designation, the uses identified there are, they're called multiple use recreation activities, continuing the existing uses with no restriction on waterborne commerce, etc. Really, both water use designations are applied in the design plan to varying areas of the river above the Willamette Falls. So no policies or criteria are provided in the comprehensive plan to justify the application of these designations, except for very general policy related to protecting the natural character of the river. The only real distinction between the limited use and the multiple use designations is that new private non-commercial docks are prohibited in the limited use areas. They are allowed subject to certain standards in the multiple use area. So based on a mapping analysis that Nick helped create, we looked at the areas in the limited use zones, and there are 41 lots in the limited use area that have river frontage and contain a dwelling. 38 of those 41 lots currently already have a private non-commercial dock. There are no vacant lots with river frontage in the limited use area are zoned for residential development. Vacant lots that are not part of parks are farm or forest designated land, which doesn't allow for a dwelling outright. Oh, thanks. I was just going to ask you to change the slide. So a significant portion of the river frontage along this limited use area is parkland. Now, on the map that I believe you received with your packet, I've got kind of two sides of the photo here that I'll quickly describe. The limited use area generally described, there's two sections. West of city limits of Canby, near the Molalla River State Park natural area, and that's the area shown on the left image with the blue cross hatching. And then the area north of Balancing Rock, south of the city limits of West Lynn and city limits of Oregon City in the right image. Based on the history, statutes, and OARs, it appears that the Willamette River Greenway was largely established to preserve areas along the river for public use, but it also recognizes that private uses like residences and docks exist on the river and should be allowed to continue to exist. We couldn't find anything in Goal 15 that requires the county to prohibit all new development in certain areas or to maintain an area like the limited use portion of the Willamette River Greenway. As such, we are proposing to repeal that prohibition on private non-commercial docks in the limited use zone. We feel that the removal is expected to have a very limited impact on the river, since it really would only allow for up to 3 more docks in this area as is. So Commissioner Wilson, you have your hand up, and thank you for your patience. I'll take your question.
Yeah, I just want to be clear. Limited use refers to a private use, right?
Limited use refers to the specific areas identified in this kind of blue shading area on the river. And the only real restriction of uses itself is this prohibition on private non-commercial docks. Is that correct?
So someone that has a property on the river and they want to put up a dock, that's considered a private use, right? Limited.
If the dock itself were for private non-commercial uses and it was within either one of these mapped areas, then that is correct.
Okay. Murph, didn't we have a conversation about somebody applied for a private dock a couple of months ago on where it was around Canby? Is that where it was?
We sure did. And yeah, it's probably a little longer than a couple months ago, I think. It was but I remember that quite well. Yeah.
Yeah.
Okay. And I'm not sure if I'm familiar with the couple months ago or the recent project, but just a couple years ago, there was an application that was made to, I believe, change the, Martha, was it to change the designation of the limited use area, or remove that limited use area designation on a property so that they could be allowed to have a dock?
Yes.
Okay, thanks.
Thank you.
Yeah, and that's happened. There was the one that happened it was within the last couple of years, and but historically there are several other instances from more like sometime back, say in the 90s, where people applied. And so there's been, I think, at least 3 or 4 where the Board of County Commissioners has acted to remove the limited use designation from a particular property so that someone could have a dock. And really, that's we're bringing this proposal forward as a result of that one that you're remembering, Commissioner Wilson, because when we got to the Board of County Commissioners, they felt pretty strongly that we should look at changing the code rather than requiring, as it stands now, somebody has to file for a comprehensive plan amendment. It's expensive. So
I have a question, Melissa.
Sure.
So this isn't the only permitting agency for a dock, am I correct?
That's correct. So the county has our own set of standards that apply to docks. Like I mentioned, we regulate size, color, shape, things like that. But in addition to the county's review, there are also permitting requirements from Department of State Lands.
Army Corps of Engineers?
Yes, and I apologize. The nuances of each application is still something I'm trying to get caught up to speed with, but it is my understanding that the Army Corps of Engineers either has their own permitting application or they take part in the DSL's application process, but they are involved in the review to some capacity.
Well, I would think so, because it's a navigable river, so I would sure think that they want to know what obstructions are being placed. And just another question is, I don't know if we can answer this, but are docks taxed? Are they taxable luxuries, so to speak? Because it'd be a luxury to have a dock out in front of your house, I would think. But
I don't know the answer to that question. I'm seeing some uncertain shaking heads.
I don't know that either. Murph, you always have the best questions. I don't know. Technically, one of the reasons that DSL regulates docks is because they're actually leasing. I mean, my understanding is because that you don't own the water, right? So you're technically getting like a waterway lease in order to have the dock in front of your property. And that's part, I mean, DSL has other things they look at, but that's one of the reasons. And so I wonder how the taxation works. I don't know.
You're protruding out onto an Oregon resource and you're calling it private. So you're saying nobody else can access this without permission. And you can do that. I mean, that seems like a moneymaker for somebody.
They get a lease. I want to say it's like a 5-year. That's what it used to be, is a 5-year cycle, and they have to re-up it. But I don't know like what the cost is or any of those details.
Great. Thank you, Melissa. I met you at a hearing. I testified at a conditional use permit hearing.
Oh, fantastic. Thank you.
Nice seeing you again.
Yes, of course. Thank you. Likewise. Commissioner Founts?
Hey, just to chime in, a quick Google search, they are taxed as floating property in Oregon, so you are paying for that. That was all.
Perfect. There you have it. Yeah, the permitting process, back to your question previously, I did have a conversation with a gentleman from DSL, and he explained to me that they do send notice when someone applies for a permit with DSL to the Marine Board, ODFW, DSL Proprietary Board, and he had listed a few other folks as well. So there's certainly more review than just the counties on docks.
Should we go on?
Yeah, I think that's all I prepared just for this particular section. Oh, so I got myself out of order here. Calculating dock area, we are going to be looking into this a little bit further. At the moment, I've got 2 slides here associated with this. At the moment, the zoning code does calculate the square footage of docks, and we define that, or we describe that as the length times the width of the outer edge of the structure. On occasion, that's caused some confusion, I suppose, of do you include the boat well? Do you not include the boat well? It just says length times width of the outer edge. What does this mean? And so Department of State Lands has this document, and this is just a snippet straight out of one of their guidance documents here of how DSL calculates the area of a dock. And so it is something that we've just applied, but admittedly, the way our zoning code reads just says length times width. It doesn't speak to whether to include the boat well or not, or how to include the gangway in that calculation. So just as an example of how other folks are measuring it, the DSL does include the area of the boat well in their calculations. And so it is length times width, and they don't exclude the boat slip in their calculations. So more to come on that. It's just something that we're still looking into. Commissioner Wilson?
Yeah, is the main concern here as to how far the dock goes out into the river? Or what are we trying to limit here and make sure that we have a passable waterway? I'm trying to understand why we having these measurements here.
Yeah, it's a great question. Thanks for asking. I think right now what we're looking at is mostly clarification on how to measure the size of the dock, because we do limit the square footage of the dock itself that's allowed. And there's some lack of clarity as to whether we include the boat slip or not. And that seems to come up more often than not when people are inquiring or looking into docks. As infrequent as we get dock questions, it's a common question when we do get it. So I think that's what we're looking at more so. We don't regulate distance that the dock can be from the edge of the water line. But I do think that's more something that the DSL does in their review.
Melissa, I like to ask the question of if this is taken into consideration. Parts of the Willamette River are channel migration zones that have been identified. Does the county recognize any of that along the Willamette Greenway?
Great question. Thank you. Now, I don't know the history as much as perhaps maybe Martha or someone else on our team does of the creation of the Willamette River Greenway design plan and how we incorporated those considerations during that process. But as for current zoning regulations now, we don't, as far as I'm aware, have any standards that speak to that.
Yeah, that's correct, Murph. There would the greenway provisions are really I think more there is definitely some habitat protection involved, but it's a lot more about public ownership. I mean, it really originated with this idea that that this at least certain folks at the state back in the day kind of envisioned I mean, not just bureaucrats, but politicians envisioned that there would be this public ownership of the entire Willamette River on both sides. Like that was the dream. And there's kind of an interesting history about it. I've read very little, but what I did read was pretty interesting, kind of explaining sort of the reality that came about as you start realizing, well, wait, we're not going to be able to afford to buy it all. And we're certainly not going to condemn it and, all the things. So it became kind of the case that, yes, there's a lot of public ownership, but certainly not the entire Willamette River. But it was more from that perspective. And really not, I don't think so much from, you're talking about channel migration, which is more like a natural hazard situation, kind of so it's not exactly floodplain, but similar. And I don't think that was really on the minds of anybody when they were designating the Greenway. At least nothing I've seen suggests that.
That could change the distance of the dock from the shore, in one storm. You could end
Oh, sure. Yeah. I wasn't really aware the Willamette had that the way that the Sandy does.
Yeah, Google it, and it
interesting.
It how many rivers have been mapped in Oregon.
Mm-hmm.
That was my push with the Natural Hazards Mitigation Plan. The Oregon State's Natural Hazards Mitigation Plan is that you have so many rivers already mapped as channel migration rivers. How come we're not talking about that in the mitigation plan?
Yeah, and for folks who aren't as totally an expert on this as Murph is, this concept of a channel migration zone, as my layman's explanation, is that the river can literally move. It's not just a matter of flooding, but the whole sort of channel of the river, as it says, migrates. And I don't know that there's any real way to build something that isn't, that's going to survive that necessarily. So it's really a challenging situation, and the Sandy seems to have it happen with relative frequency.
Yes, Molalla also, I guess. Maybe not as much as my neighborhood, but yeah.
Yeah.
Right.
Have a big flood, and then the whole river goes, okay, I'm going to move over here now, and now the channel is just sort of quote unquote permanently someplace else until the next time it moves. So yeah.
Well, this kind of reminds me of the discussion I've had before with, ocean property and people access to the ocean, and you can't block off people access to the ocean because the ocean's free access. And now we have a river, and it's kind of public property on the river. So, it's a very confusing situation.
Yeah, I mean, the Willamette, we don't, there is a fair amount of public ownership. In fact, we've been talking about maybe needing to do a map for purposes of some, another project we're working on. But yeah, where you've got public parkland or maybe a road right of way that is, dedicated to the edge of the water, but we're not requiring public access to sort of general. There's a lot of private ownership along the Willamette. The river itself, though, the water is available to anybody if you can figure out how to access it from a legal point. So,
Jennifer, you have something?
Well, we go fishing down that section on the Willamette all the time. We just get in at Charbonneau at the docks there. And I mean, those docks aren't going to get in the way of public use of the Willamette at all. I mean, there's tons of them, and I mean, if you're fortunate enough to have property on the Willamette, I mean, what a wonderful thing to be able to have. But yeah, they don't get in the way of public access. We go up and down the Willamette all the time on the pontoon. That was it. I just wanted to point that out.
Great, thank you very much. If there are no other questions or comments on the Willamette River docks, I think we can go to our next slide, and I can still talk to you about the Willamette River Greenway. This specific point here really brings us into our third amendment, or I think Martha calls it a bucket of requests or topics tonight. Our third bucket is public requests, and really we've had one interested party who's interested in pursuing or having us look into pursuing an amendment to the 35-foot height limit that is applied to residential development in the Willamette River Greenway. So currently the zoning and development ordinance limits the height for all residential development in the Willamette River Greenway boundary to 35 feet. Within the urban area, the vast majority of residential lots within the Willamette River Greenway boundary have a low density residential zoning designation. And that low density zoning designation already has a height limit of 35 feet for development, even outside of the Willamette River Greenway. There are, however, a number of lots within the Willamette River Greenway that have a high density residential zoning designation. And I've got a map of that. Yeah, thank you. I've got a map of that on the next slide. Perfect. The high density residential zoning designation is intended for multifamily development, and outside of the Willamette River Greenway has no specific height limitation. And so this packet of amendments is proposing to remove the height limit for lots that are within the Willamette River Greenway boundary that are also within the high density residential zoning district. And so this map here highlights the very few lots that are both within these two areas, the high density residential zone and the Willamette River Greenway buffer. Should I take questions now? Or should I actually, you know what, give me one moment. I don't have too many more comments to make on this piece, and then I'll take your comments or questions. When we consider the goals of the Willamette River Greenway designation, it's really to minimize visual impacts on the river. We've discussed whether the height limit should remain for development in the high density residential zone. That's within a certain distance of the river, maybe 100 feet or 200 feet of the river, or if there should be some buffering or screening requirement imposed. But we're not proposing either of those restrictions for a number of reasons. Those were provided in the packet, but just on a high level, I wanted to just touch on them tonight. There are only a few lots that would be wholly or partially affected by this change. Many of them are already developed, and most of them are more than 200 feet from the river. There's already development visible from the river. New developments and other locations within the Willamette River Greenway are not required to be screened. Screening of a structure that exceeds 35 feet in height is also somewhat impractical. Even tall trees that already exist on the property are unlikely to screen a structure from all vantage points. And then lastly, adding more requirements on housing development is somewhat counter to the recent mandates from state for local jurisdictions to streamline processes and remove barriers to housing development. So with that, I will take questions. I'm sorry I didn't see who raised their hand first, so I'll let you guys fight it out.
Jennifer, go ahead.
Sorry, I think it just didn't lower my hand from last time. I apologize.
Oh, perfect. Thank you.
Go ahead.
Okay, how much property or area are we talking about here that we're looking at with this amendment?
Great question. I may call on Nick Hart, who actually did this mapping analysis for us. Nick, do you recall how many lots specifically were in this area?
I didn't ever count the number of lots or the number of acres, but it's limited to what you see on the screen here, which is just tucked right up against the city of Milwaukee at sort of the north end of our urban unincorporated area along River Road primarily.
Can you see my mouse or no?
Yeah, I can see the map. You said this was in the Milwaukee area?
Near Milwaukee.
Yeah, it's areas near Milwaukee. If you're familiar with where Southeast River Road sort of comes off of McLaughlin Boulevard and heads up the hill a little ways, that's where these lots are located for the most part. You can see there's kind of a strip of parkland shown here. That's the trolley trail that comes down, and so you've got a little.
I'm very familiar with Milwaukee. I live in Milwaukee.
Perfect.
Okay, so what you're talking about here is increasing the size of the residential property to what?
Yeah, we're talking about right now there's a height restriction on all residential development to 35 feet. And what we're talking about is eliminating that restriction just in these areas shaded in orange. These areas are the high density residential zoning districts, and other high density residential zones outside of the Willamette River area don't have a height restriction currently. So the proposal would be to remove that height restriction for these specific zoned properties within the Willamette River buffer.
Okay, since I live out here, I know that property is pretty well developed. So what you're talking about is allowing these people that own that property there to either sell their property and give it to development to put in something else that's going to be higher. Is that what I'm understanding here?
That would be correct.
So, Commissioner Wilson, the request came from Willamette View, which I mean, I know you're familiar with this area, but Willamette View is interested in doing some additional development on their campus there on River Road, and they would like to have a building that is taller than 35 feet. And so they're the ones that actually asked the board if they would be willing to initiate this text amendment. And the board hasn't ruled on it. They've just said, yeah, let's take a look at it. And so that's the impetus for this. It does affect some land that's not owned by Willamette View, but I think that's probably, trying to remember, Martha, is there much likelihood that this is going to be an issue in the other locations besides Willamette View?
So
Do we know?
I don't think so. And there's a couple of reasons. These properties that are orange are the only properties in the entire urban unincorporated area that are zoned high density residential and also intersect in some way with the Willamette River Greenway. The Greenway boundary is this blue line. So the reason that we don't think this will have a significant impact is because, like, for example, this property, because it happens to be on the outside of the Greenway line, they could currently build as tall as all the other development standards would allow them to. But this property, which is the Willamette View property, if the development happens to be, say, right here, they don't have a height limit. But if it happens to be right here, they have a height limit of 35 feet. Same thing with this property. These, I think, are very steep. I don't know that those could even be developed. There's a couple of single family homes on these properties. They're developed for high density residential. They could redevelop right now. They just would be limited to the 35 feet. Whereas if we take this away, these few small properties could be redeveloped with a little bit taller structure. That is true. I think the impact, and these are all single family homes over here, the impact is very little. And when you look at the map, yes, there's topography and things that you can't see on this flat map, but the biggest impact really is going to be on Willamette View's property right here, which would allow them to develop similar to just right over here or right up here, which is literally the same distance from the river. It just happens that there's a bump out for the greenway and no discernible reason. There is already development here. It's just not over 35 feet.
So what type of maximum height are we talking about here?
So the HDR zone doesn't have a maximum height limit, but it does have a maximum density. So there's some natural limit because it's 25 units currently anyway. I mean, we're not proposing to change it. It's 25 units an acre. And so because of that, there's some, you know, they're not going to go up sort of like infinity, right? Because they can't, it's not going to pencil out, given the maximum density that they can have. And then there's well, I'm going to start laughing if we start talking about the solar separation requirements. There are some things that theoretically kind of regulate building height depending upon how close you are to other structures, because there's some rules about how you can or cannot shade adjacent structures. But Martha's the only person who understands those rules, so I'm not going to even try to pretend to explain it. But technically, there's no height limit. I just think realistically, though, there probably is.
Okay. I'm not opposed to this. I just wanted to understand what was going on over there in case I get some, in case this thing gets going and approved, they're going to be asking me what happened here. And I just want to understand, so I can communicate with my local folks. Okay.
Yeah, absolutely.
Thank you.
Okay. This was the last item, unless there's other questions about the height limit. There's one last slide. Jennifer already really has covered this. It's just the upcoming meetings. We are going and talking to the board. We're doing a policy session with them on March 10th. She mentioned that your public hearing for the whole package of amendments for this minor and time-sensitive amendments, the entire package, we have scheduled for public hearing before you on May 11th, and then we don't have a hearing scheduled yet in front of the board. We're expecting sometime in June. We're hoping for sometime in June. And that's it. That was a lot.
Okay, though, it's 9 o'clock. We're all right. We haven't like taken this into something totally unrealistic, and it's not 11.
This is true.
New business?
I don't think there's new business. Let's see, the recruitment's open for the Planning Commission. And I believe Darcy told me that both Commissioner Lopes and Commissioner Murphy have foolishly agreed to re-up for another term with us. But I think the recruitment's still open for a bit. So that's happening. I don't think we have anything else that's new.
Okay. And so we have an idea what our next Planning Commission meeting is. Looks like March 23rd.
March 23rd. So your first meeting in March is canceled, whatever date that would be. If I'm quickly doing math, it'd be like the 9th probably. That one's canceled. The 23rd, Martha will be back to talk about, I know, everything is Martha. I don't know how she finds time in her day to do all these things. To talk about the ZDO diagnostic report again, which you've had background on previously, but it is wrapping up. There is actually a product coming that we're then going to have to do something with. So she's going to come and talk to you about that so that we're kind of setting the stage. Is there anything else you want to say about that, Martha?
No, everyone's tired of hearing me talk.
Well, I wouldn't go that far. So that's happening. And then
I'm tired of hearing me talk.
At the moment, there's nothing scheduled for April, but you know, you kind of never know. So potentially there could be something, but right now, the next thing after the 23rd would be the May 11th public hearing for these minor amendments.
Okay, minutes. Do we have minutes from last meeting? We need to, okay?
Did Darcy put those in the packet?
Yes, they were.
Okay, perfect.
Anybody have anything to say about the minutes? Any corrections or disagreements?
I recommend we approve the minutes as published.
Thank you, Michael. Do I have a second?
Second.
3 seconds. Vote.
I can call the roll. We should do a vote because it never works out very well when we're going to do a voice vote. And Darcy has moved on. So I don't. If you weren't here, you can abstain. I won't remember for sure. So Commissioner Satter.
Aye.
Commissioner Founds.
Yes.
Commissioner Lee.
Yes.
Commissioner Wilson.
Aye.
Commissioner Lopes.
Yes.
And Chair Murphy.
Aye.
Motion passes.
Thank you.
I have a question here for Mr. Hart. How long you been with the Planning Commission, and what's your background?
Sure, I've been with Clackamas County as a planner for, I guess, coming up on 2 years in probably April or May. Before that, I worked in a variety of different contexts doing planning adjacent things, primarily focused on climate change adaptation projects, and so long range planning for different environmental and natural resource related topics, both in Washington and California.
What's your educational background?
I have a degree in planning, public policy, and management from the University of Oregon.
Oh, great. And Melissa Ward, your background with the Planning Commission, and what's your educational background?
Yes, sir. I have a bachelor's degree in geography and environmental studies. I then obtained my master's degree in planning from the University of Calgary. I've been a land use planner for 9 years. I started working in current planning in Montana and then moved to Oregon shortly after. I started with the city of Gresham when I first moved to Oregon, and then started with the county 5 years ago.
Jennifer, you're doing a great job in recruiting some good people.
These two are pretty darn fantastic, I have to tell you. So I completely agree. I'm not going to take credit, but I agree with you.
We're happy to be here. It's easy to work for somebody so fantastic.
Oh. Okay.
Okay. Well, fantastic job planning. Thank you. Done very, very well. Commissioners, thank you. I think we're ready to close. I'll see you soon.
Good night, everyone.
Thank you. Have a good night.
Thank you.
Good night.
Good night.
Good night.